Good afternoon, everyone. Welcome to the 7th webinar organized by Scope on issues in arbitration and future of virtual hearings. We have received an overwhelming response for today's webinar, with over 550 participants registering with us and many more participating in the live webinar through YouTube and Twitter. Given the significance of the subject, especially in the present times, when funds of the companies are blocked in disputes, we have ensured that we bring the best for you in the field so as to guide us and sail us through. We are privileged and honored to have with us Justice Vibhu Bakru, Judge of the Delhi High Court. Sir was appointed as Judge of the High Court in 2013, and prior to that, Sir was designated as Senior Advocate in the Delhi High Court in 2011. Sir has presided over several important cases and is one of the leading thinkers in arbitration law and practice in India. Thank you, sir, for taking out time for us and being with us. Welcome to the webinar, sir.
It's a pleasure.
We are also privileged to have with us Gaurav Pachnanda, Senior Advocate, Supreme Court of India. Sir has a distinguished practice in Delhi and practices before the Supreme Court and other courts and tribunals in India and abroad in the areas of commercial and corporate litigation and arbitration with a significant multi-jurisdictional component. He is also the door tenant with Fountain Court Chambers, London, and also a registered lawyer at the Singapore International Commercial Court. Thank you, sir, for being associated with us and sparing time for us. Welcome, sir.
It's a pleasure.
We also welcome Saurav Lahiri, sir, barrister at law, London. Sir specializes in international arbitration and construction and engineering disputes and has practices in Singapore, Hong Kong, Dubai, and Beijing. We also welcome Shri Atul Sopti, Director General Scope, and the mentor behind the series of webinars that Scope has been conducting. Sir is a visionary leader having a versatile professional experience of nearly 4 decades. Before leading Scope as DG, Sir was CMD BHEL, a Maharatna public sector enterprise. Welcome, sir.
Thank you. Thank you.
We also extend a welcome to Shri Anuj Agrawalji, Member HR Airports Authority of India and Executive Board Member of Scope. Sir has nearly 3 decades of experience in the public sector space and known for his flair for perfection, transparency, and efficiency. Welcome to the webinar, sir.
Thank you.
With this, I now request DG Scope to welcome the panelists and give his opening remarks. Over to you, sir.
Thank you, Samriddhi. Good afternoon, everyone. Respected Justice Vibhu Bakru, Sitting Judge, Delhi High Court, Shri Gaurav Pachnanda ji. He is the Senior Advocate and Supreme Court. Then our friend Shri Saurav Lahiri ji, who is the Barrister in Law at King Chambers, London. Shri Anuj Agrawal ji, he is the Member HR, Airport Authority of India. As Smriti mentioned, that this is the 7th webinar in the series, which started from 8th April onward. Incidentally, the first webinar was on the fundamental concepts of international EPC contracting, the legal perspective, where we were fortunate to have Mr. Saurav Lahiri. He was the one who started this particular webinar on the 8th of April. I would like to welcome Justice Vibhu Bakru ji and express my gratitude for accepting our invitation and for sharing the thoughts and sparing his valuable time. Thank you, sir, once again for joining this webinar. We also, our heartfelt gratitude to Shri Gaurav ji for accepting our request and joining this webinar. Mr. Lahiri, he has joined this webinar from Singapore today, and he is now well-known face among the PSC fraternity. In fact, I have participated in many conventional seminars and conferences here, and the first webinar, as I mentioned. Thank you, Mr. Lahiri. We consider you as part of Scope now only. Thank you.
Thank you.
Now, the presence of 3 distinguished experts here, in fact, they add the value to the already very significant subject we are having today. In fact, all of you may be aware that India has now moved to the 63rd place as per the World Bank ranking of the ease of doing business, as per the 2019 ranking, which was in fact about 5 years back in 2014, it was 142. And it speaks very well for the government of India, who have taken a series of steps in this. 142 to 63 in a 5 years period, a very short span. And ease of doing business comprises of, in fact, 10 factors. And one of the factor is basically enforcing the contracts. Unfortunately, that's one area, enforcing the contracts. That parameter we rank still 163 out of the 190 countries. So that's an area which needs a lot of attention. Hence, this particular webinar is of great importance, because as per the reports, India takes nearly 1,445 days to resolve a commercial dispute to a local first instance court, which is almost 3 times what is being taken in the OECD countries. In fact, in 2017, Scope conducted a study among the 50 leading PSUs about the kind of legal cases they are having and the count of the type of money they are spending as legal expenses. And we found that the 50 companies are having ongoing cases of almost 41,000 legal cases, which means over 800 legal cases per PSU. And they were spending to the tune of 900 crores for these cases. So it shows that how important this subject is, that how fast we need to resolve these issues, because huge amount gets blocked in these cases. And not only huge amount is blocked, many projects get stranded because of that. And today, when we are facing the pandemic situation in India and all over the world, we find that these projects have to move fast. If any cases are there, they need to be resolved, and all these development work has to start. So there are 2 things, in fact, for resolving. One thing is that initial contract itself has to be drafted properly, and second thing, there should be proper land dispute system should be there. And here I like to say that this is I mean, there need to be some kind of alternative dispute resolution system should be there, which need to be addressed by the organization, by the contractors, by the all stakeholders. Scope, in fact, I like to share with you, has got the Scope Forum for the Conciliation and Arbitration, SFCA, and which provides the arbitration through the 400 empaneled experts, which are Supreme Court judges, retired Supreme Court judges, High Court judges, legal advocates, and a number of PSCs, chairmen, directors, senior officials. My colleague would be making a small presentation on this particular subject, that how the SFCA is working. Now, moving further, we are in fact facing this problem of social distancing, because we are in public sectors and otherwise also. For the arbitration, we are used to having a kind of discussions, face-to-face discussions, while resolving the arbitration issues. Now the time has come for the virtual hearing, and we will be able to hear on the virtual hearing from the experts today also. Who would be better to address all these issues, or whether whatsoever issues we are facing in the arbitration or the virtual hearing, which is going to the future. We have today the Honorable Judge of the High Court. We have today a senior advocate from the Supreme Court, an expert in this field. And above all, we have our friend Mr. Saurabh Behri, who has got the lot of expertise, international experience in this particular field. Ladies and gentlemen, I would request all of you to make maximum use of this opportunity, and definitely most of your issues and doubts will get resolved after listening to the experts. Thank you. Thank you very much. Once again, I welcome all of you to this webinar, which is being organized by Scope. Over to Samriddhi. Thank you, Samriddhi.
Thank you, sir. Thanks a lot for your guidance, and thank you for highlighting the current issues. As sir mentioned, that Scope is an institutional arbitration wing under the name of Scope Forum of Conciliation and Arbitration. Our colleague Lippy Singh will take a minute in making a presentation about the same. Over to you, Lippy.
Thank you, Samriddhi. I will be making a small presentation on SFCA.
Lippy, can you please do it, expand the screen? Please put a slideshow.
I'll just do that. Good afternoon, everyone. Since we have a very learned panel joining us today, I will just take a little bit of your time to exhibit what SCOPE is doing for the arbitration and conciliation process. Formed with the purpose of expediting settlement and reducing avoidable expenditure by PSEs, SCOPE formed SCOPE Forum for Conciliation and Arbitration in 2003, which was inaugurated by Shri Santosh Gangwar, the then Honorable Minister for Heavy Industries and Public Enterprises and Parliamentary Affairs. Subsequently, the SFCA rules were published in 2003, which were amended upon 2017 to incorporate changes in legal framework and needs of the business community. Coming to why should you choose SFCA? SFCA has over 400 experienced panel of arbitrators, conciliators, which comprise of retired judges of Supreme Court, High Court, retired secretaries, among others. We provide end-to-end solution for arbitration, right from administering, overseeing arbitration proceedings, and assure settling disputes in shortest possible time that lead to savings in cost. As we are talking about virtual hearings today, we would like to inform that SFCA provides state-of-the-art facilities for video conferencing and webinars, and facilities such as projector for live projection of proceedings on large screens. We also provide halls with adequate seating capacity of 15 people and all the minimum requirements arbitration may require. These are located at prime locations of Lodi Road and Lakshmi Nagar, which is quite accessible to litigants and lawyers. Besides ensuring that you have an effective and efficient arbitration process, SFCA assures there is continuous capacity building of present arbitrators as well as those in arbitration profession. SFCA organizes capacity building programs on various aspects of alternate dispute resolution process, and today's program is a part of our endeavor, and we are joined by all our SFCA members. We provide arbitration to many organizations like Indian Oil, Bharat Petroleum, SAIL, and NHPC, etc. These organizations have included SFCA clause in their contracts for resolving any disputes that may arise. Therefore, we request you to associate with us and incorporate SFCA for resolving disputes. That would be all from my end. Thank you.
Thank you, Lippy. Thank you for a very concise presentation. With this, we will be starting the technical presentation on today's webinar, Issues in Arbitration and Future of Virtual Hearings. Before that, I would just brief you about how the webinar will move. We will have two technical sessions being taken up by the three learned panelists with us. After that, we'll have a Q&A session. Now, the Q&A session will move in two ways. One, we have already received some questions in advance, which the learned panel will be taking in due course of the presentation. And some of them we'll be taking up live. The attendees have a screen on their right side which says questions. So all the attendees can type the question there during the webinar, and the panelists will take it up one by one. So with this, now I hand over the forum to Saurav Lahiri sir to please take ahead the webinar forward. Over to you, sir. Lahiri sir, over to you.
Thank you, Smriti. Thank you, Mr. Sopti, and my greetings to my fellow panelists, Justice Bakru, Gaurav, and all those who are sparing time on a Saturday, taking time away from your family to watch this. We'll be discussing a couple of broad issues today. One is of asymmetric clauses that allow a party to make unilateral appointment of arbitrators. And secondly, issues dealing with virtual hearings from perspectives of both counsel, which Gaurav and I will touch on, and as well as from the bench, which Justice Bakru will touch on. I'll start off with this concept of this issue of asymmetric clauses. And we know that in arbitration, one of the key aspects is mutuality. So parties go to arbitration because they agree to go to arbitration, and both parties must do so. If there is no valid arbitration clause, one defaults to court proceedings. But because arbitration is permissible by agreement of the parties, an arbitration agreement is just like any other contract. Parties can agree anything that they want in a contract. Compare this to being in court, where the rules of engagement are set by the law, by the legislature, and implemented by the judiciary. In arbitration, subject to some restrictions, the parties set the rules. And this principle of party autonomy is a cornerstone of arbitration. So for instance, we have seen arbitration clauses that allow one party the choice of going to court or to arbitration, but restricts the other party's choice to only go to court. And these jurisdiction sort of clauses are quite common in finance agreements to basically bolster the ability of the lender to sue the borrower in any jurisdiction where the borrower resides or has assets, whereas being sued only in the jurisdiction that the lender chooses to be sued in. These clauses are asymmetric in that both parties don't have the same rights to access to jurisdiction, but they have been considered to be valid clauses. And this is across the board. In England, in Singapore, and Hong Kong, these sort of asymmetric clauses are valid. Now, some say that this affects the equality, the principle of equality within the parties, between the parties, which is enshrined in the Untittled Model Law, and which has then been made part of many arbitral institution rules and also national legislation, including the principles that are applicable in India. However, it's important to remember that the principle of equality in arbitration under the model law applies to parties in the arbitration. So a tribunal is required to treat parties equally. There is no requirement for parties to treat each other equally. This principle of equality, therefore, only comes into play once the arbitration starts. But today we are discussing clauses that are part of contracts between parties and where there's an inequality or perceived inequality between the parties. So the principle of equality in arbitration is not offended by such clauses. How does this translate into a party's choice of an arbitrator? For instance, can such imbalance between the parties' powers to appoint an arbitrator be allowed? We know that a lot of people say they prefer arbitration because in arbitration, you can choose your judge. Whereas if you go to court, you can't really decide who the judge will be that hears your case. In arbitration, you have some modicum of control. However, this concept must be properly understood before we get into the issue of appointment of arbitrators. It is, of course, not correct that parties always have the right to choose their arbitrator. Take, for instance, a sole arbitrator. If parties don't agree who that sole arbitrator is to be, that appointment is made, if it's an institutional arbitration, by the institution, or if it isn't, then by the court. That means somebody else is making the choice on behalf of the party. Can it then be said that the parties really had a choice of the judge who was going to decide their case? So maybe the concept should be refined a little further into saying that in arbitrations, parties have the option of choosing the person who is to decide their case, rather than parties can choose their case. Because as we can see in a situation of a sole arbitrator or the chairperson of a three-member tribunal, that is not always the case. Now, of course, when we come to three-member tribunals, there is the ability of a party to choose one arbitrator. At least each party chooses one arbitrator. So there is a choice. You can choose one of the judges. But even then, as we will see, the right is not unfettered. It's not a complete right. In international arbitration, and we will also see through Gaurav and Justice Bakru in India, there are some basic principles that must be complied with. The first principle, which is not derogable from, is the principle in law that no man can be a judge in his own cause. And that applies across the board. So for instance, a party cannot choose himself as being one of the arbitrators of a dispute, even though his counterparty may agree to that. And we see this encapsulated in international arbitration by what's called the IBA guidelines on conflict of interest in international arbitration in a category called the non-waivable red list. So there is a red list, which are significant factors, and a subset of that red list is a non-waivable. So a party cannot be a judge in his own cause is a non-waivable element. Another principle is that a party cannot have the arbitrator cannot have a financial interest in the outcome of the case. He has to be independent and impartial, not just of the parties, but also of the outcome in the case. And a very interesting decision handed down in the English courts about a few years ago, a case called Costley and Bingham brought this to light, where the court considered that the prospect of repeat appointment of an arbitrator by a party leads to a degree of financial dependence of the arbitrator on the party, because in that case, it was also shown that the party had a blacklist of arbitrators who it would not propose because they would not find in its favor. And therefore, the converse is that the party would propose arbitrators who would be expected to find in its favor. And because an arbitrator is paid for his services compared to a judge, there can be a question of financial interdependency between an arbitrator, his decision-making, and repeat appointments. And this issue of repeat appointments, of course, has now been dealt with legislatively in India, but has always been part of the IBA rules as a cautionary factor. So this gives you an idea of why a lot of people have an instinctive reaction to being forced into a limited choice of people in arbitration, in choosing the arbitrators. And that is why both the IBA guidelines and now the Arbitration Act of India lays down certain principles. Now, just pausing there for a minute, you might ask, why does it really matter? If my other party has agreed to appoint an arbitrator that I choose, or a limited set of arbitrators, why shouldn't I be able to go ahead? And the principle behind this is because arbitration awards are final and no one really can look into it. Even courts have very limited ability to look into arbitration awards. And therefore, if certain basic precautions are not taken, parties can actually collude to get arbitration awards issued that could be a cover for things like money laundering. Because once an arbitrator decides something, that award can be banked in the concept of accounting, and money can be paid pursuant to that, which will appear really clean. So if parties are allowed an completely unfettered right to decide who their arbitrator is going to be, they can enter into a lot of arrangements which may be very difficult for the courts or any other oversight body to uncover. So that is the reason, to avoid these sort of risks, these principles exist in international arbitration. Now we come to the broader question, which is defined even more in India when Gaurav and Justice Bakru speak about it, of choosing arbitrators from a restricted list. Is that in itself a problem? The answer is no. We know that in many technical contracts, construction contracts, engineering contracts, parties often agree a certain list of characteristics that the arbitrators must have. Might they be engineers or lawyers? They should have at least 10 years of experience. Or in international disputes, that the arbitrator should not have the nationality of one of the parties of the contract. So these sort of restrictions often exist. So the concept of restricting a choice is not really a problem. And we saw this some years back in England in a case called Jivraj and Hashwani, where the parties, both of whom were members of the Ismaili community, agreed that all three arbitrators must be respected members of the Ismaili community. And the arbitrators were appointed and everything was fine until one of them resigned. And in replacing that arbitrator, one of the parties said that this clause offended certain principles of equal employment legislation in the UK because it restricted somebody who you could appoint to provide personal services. And it went all the way up to the Supreme Court, and the Supreme Court said no. In an arbitration, the arbitrators are appointed with the purpose of having a duty to the party. And while it is a contract of service. It is not a contract for personal service under the direction of the party. So implicitly accepting that parties can decide to restrict the choice of arbitrators to a certain set criteria or a certain set group. But there, the parties had mutually agreed to limit the arbitrators to a group from which both parties were to choose. What happens if the group is limited by one party, so the other party has only a very defined group of people to choose from? So they're restricted in the choice of arbitrators. Nowhere has this been litigated more in the world than I think in India. And on that, I will pass the baton over to one of the brightest lawyers I know who will deal with this next session, Gaurav Pachanda. Gaurav, over to you.
Thank you, Saurav. I just wanted to discuss very briefly as to how the law has developed in India with respect to unilateral appointments of arbitrators. Before I start discussing how the precedent has evolved, of course, I'm sure Justice Bhakru would later on express his perspective, but I think India as a jurisdiction was faced or has been faced for quite a while with the problem of how much do you interfere with awards. And over the last 5-7 years, we have now seen that there is almost an international benchmark that Indian courts follow of not interfering in arbitration awards at all. And yet, at the same time, particularly in the context of a lot of government organizations, there was this problem where even if the result that had been arrived at by a unilaterally appointed arbitrator, there were, from a judge's perspective, there were concerns that would sort of make a court not let it pass. There was an induced or sort of invitation to interfere in that award because something or the other was ex facie visible on the award, and it was possibly because there was a unilateral appointment. The person acting as an arbitrator was an appointee, and perhaps his award reflected some degree of colored vision. In the context of this problem, until the 2015 Act came, I think there was very little that courts could do, and therefore the best that the courts did in the pre-2015 regime was to ensure that wherever there is a unilateral appointment clause, it is construed in a very strict manner, and wherever there is a deviation from it, or it is incapable of being followed strictly, the approach of the courts was that then we will say that this clause has become incapable of functioning. So in Newton Engineering, where there was a clause that said the executive director or no other person alone will be either the arbitrator or the person appointing the arbitrator, the Supreme Court, in the facts of that case, the post of executive director no longer existed. And the Supreme Court said that in that case, this unilateral appointment arbitrator has become incapable of functioning. Similarly, in a series of judgments in Datar Switchcare, where a party had an appoint to unilaterally appoint an arbitrator, but had not acted within a period of 30 days, or even thereafter, until the other party had made an application for default appointment, courts concluded that unilateral right to appoint an arbitrator would be deemed to have come to an end, and that right is forfeited. However, what has happened after the 2015 amendment is a more interesting development. 2015 amendment to our Act has introduced two concepts in terms of eligibility and disqualifications of arbitrators. So there is the fifth schedule, which obligates arbitrators to disclose potential conflict or perceived conflict under section 12(1). This would only give rise to a challenge that you can assert before the arbitrator. But the seventh schedule, read with section 12(5), creates a schedule that lists out grounds of complete ineligibility. So notwithstanding any prior contract to the contrary, the person, if he qualifies or is hit by any of the criteria under the seventh schedule, is ineligible for appointment, unless after the dispute has arisen, there is again a written agreement of the parties to continue with that kind of a unilateral appointment. I think that although the criteria under the 7th schedule applied only to arbitral appointments and to arbitrators, I think the 7th schedule created a window, or sort of opened a window for courts to not only enforce the sort of ineligibility criteria under the 7th schedule very strictly, but in a lot of public sector undertaking contracts, the clauses were worded in such a manner that either the named arbitrator, let's say the managing director, had to act as an arbitrator himself, or if he was unable to act, then he could appoint a nominee in his or her place. So the Supreme Court in TRF Limited held that in clauses of such nature, if the managing director himself, or let's say an executive director himself of the party that is in arbitration, has become ineligible by virtue of Schedule 7, that means that he will also lose the ability to appoint an arbitrator under the alternative provision of the arbitration clause. So TRF Limited is a 3-judge judgment of the Supreme Court that extended the principle of the 7th schedule not only to the named arbitrator, but if the named arbitrator was also the appointing authority, or could also be the appointing authority for a unilateral appointment, the criteria of 7th schedule was applied to the appointing authority for the purpose of disqualifying him from making that appointment. And it was held that unilateral appointment cannot be made. As a result of that development, there is now a sort of, not a cascading effect, but an incremental change in the policy that has governed appointment of arbitrators under unilateral appointment clauses. In Perkins, the Supreme Court finally said that even if such unilateral appointment clause does not envisage a named arbitrator who will, as an alternative, be the appointing authority, even if the clause only appoints or even if the clause only envisages an appointing authority for the purpose of unilateral appointment, but the appointing authority suffers a disqualification under the 7th schedule, then we will apply the criteria of the 7th schedule to the appointing authority to say that that unilateral appointment cannot be made. This was one step further. So the development was that the 7th schedule, which was meant to apply to arbitrators, was applied to appointing authorities. The Delhi High Court has actually interpreted this, taken this a step further, where instead of a named arbitrator, they have applied the same principle to not only the named arbitrator, but to the party. So, for example, in an arbitration clause that says that a unilateral appointment will be made by party A, the Delhi High Court has held that based on the Perkins judgment, the principle will also apply to party A, although party A per se is not capable of suffering the disqualification of the 7th schedule, but it has an interest in the outcome of the arbitration. So, for example, in Predator cable television, the Delhi High Court said that although the unilateral appointment is to be made by the company and not by its managing director, but yet the principle of Perkins was interpreted to apply to the company as well. Although there was no managing director who had suffered or who was subject to a disqualification under Schedule 7. These 2 or 3 cases are very progressive, as I said, in the context of this miscarriage of justice that was often visible, I believe, from a court's perspective in unilateral appointments, but they relate to sole arbitrators. In the case of a panel of arbitrators, there is a slight tension between the case law. For example, in Voesta Alpine, the Supreme Court was faced with a situation where one of the parties had a panel, and out of that panel, it could give a sub-panel or a list of 5 arbitrators to the other side, and the other side then had to choose one arbitrator. And then so there was a restriction. The Supreme Court looked at this case and said that it is perhaps not appropriate to even suggest a shortlisted list of 5 arbitrators to the other side. The option should be given to the party appointing the arbitrator to pick any one person from the panel, and then the other side can also sort of pick a person from the panel. But in Central Organization for Railway Electrification, which is a more recent judgment, a 3-judge bench of the Supreme Court has taken a slightly different view, where they have said that in a similar clause, they have in fact upheld the entire clause, saying that this clause envisages that one of the parties will pick a list of 5 from a panel, suggest it to the other side will recommend 2 out of those, and then then this party again will pick one out of those as that party's arbitrator. So the Supreme Court took a view that, strictly speaking, this is not a unilateral appointment. There is a lot of counterbalancing the appointment of arbitrators. But however, I mean, simply stated, the result of this jurisprudence with respect to a panel of arbitrators is that, I mean, there is a lot of interference by the counterparty in the appointment of the nominee arbitrator of the other side. Broadly, I think this is where the law is. I think at some stage there will have to be greater clarity on the appointment of a panel of arbitrators, and I believe that the principles that the Delhi High Court has now followed and Perkins' judgment has followed may then have to be imported to a panel of arbitrators as well. And perhaps it may not be proper to even force a party under an arbitration agreement to pick one out of the 5 that the other counterparty suggests. And it might be better, or perhaps the jurisprudence might evolve in a direction where each party will have absolute autonomy in appointing its own arbitrator. But as I said, the entire jurisprudence has developed in the context of a peculiar situation where I believe that there is this policy objective of minimum interference in awards, and yet at the same time there is a big problem that is almost an invitation, or sort of, you courts can't just look away. In most unilateral appointed arbitral awards, there was a sense of unfairness or injustice that, or as a matter of fact, even if there would not have been an injustice, there was a huge incentive for the party that was unsuccessful to raise this issue right up to the last court, because there was a perception that the party suffered, that the arbitrator was not mine, he was appointed by the other side. I think broadly, that is the development of law in this area so far in India. With that, I would pass on the baton to Mr. Justice Bakru, who, of course, lawyers have all these views and perceptions, but in the end, the court has the last word. So I look forward to his views on this.
Justice Bakru, you are on mute.
Right. Thank you, Gaurav. And that was, well, it's courts don't normally have the last word because we are in a process of evolving law. So law in our country doesn't really change. It sort of metamorphosizes itself over a period of time. It's a process of evolution. But thank you for actually laying down the land, how the land looks in this ecosystem very, very succinctly. And really the 4 judgments or 5 judgments that you mentioned really cover the spectrum. But let me give you a different perspective of where we are coming from and where, in fact, the legislative policy is coming from. See, one thing is very clear, that arbitration can't be done away with. It is bound to grow. It is bound to develop further. And for no other reason, because there is no other alternative. The judiciary today does not have the resource bandwidth to take over the kind of litigation that it requires to deal with. Now there is a lot of stress, as in fact Mr. Sopti also pointed out, about ease of doing business, and one of the factors is to have commercial division and commercial courts. So there may come a time where persons may actually elect, should we go for arbitration or should we go for a commercial court? But I think as of now, if you're looking for an expeditious disposal, there is really no alternative to arbitrations, no real alternative at this stage. So having concluded that we have to somehow engage in arbitration, particularly when it comes to PSUs and other entities that have a large exposure to litigation, we must examine from where PSUs have been coming. Now, if you look at the traditionally, and even today for that matter, PSUs enjoy a very strong bargaining power. On most of the contracts, it's just take it or leave it, except for a few contracts where there is some technology involved, or where the service providers or the contractors are very few. There may be some room for negotiation, but by and large, the contracts are being drafted and presented by PSUs to the contractors. And they have always included standard format arbitration clauses, which have been advised by the advisors and where some amount of thought would have gone through. Now, if you look at all those clauses, one thing really stands out is that there has been a serious effort to ensure that the control of the arbitral tribunal, the appointment and control of the arbitral tribunal, constitution of the arbitral tribunal, actually rests with one party. So rest all is actually given to winds as who else, how the matter would progress, what would be the procedure. But one thing has been defended very strongly is that the arbitral tribunal must be constituted by one party. Now you've pointed out the ecosystem which we currently are in. This kind of unilateral clauses may not always stand. You have three instances which you gave, which were by the Supreme Court, Westline, where they said expand the panel of arbitrators. You had TRF and IGRO, where it said that if you are a person who is disqualified under 7th schedule to act as an arbitrator, you can't then appoint an arbitrator itself. And then you have Perkins finally, which said that even if you are not named arbitrator, but if the person who's to appoint an arbitrator is otherwise disqualified, they can't appoint an arbitrator. And then, of course, you mentioned the Delhi High Court judgment that is yet to be tested, and that's, I think, Arbitration. Now, Arbitration had a thought, and it said that why is it that an appointment by a managing director is not permissible? It's because he has an interest in the arbitration, and he is disqualified. So why should this principle not be applied to the decision makers? If the decision maker in a company is the board of directors, then the board of directors is also disqualified. And this thought was then expanded in Arbitration. Now, this view has to be tested because it's a Delhi High Court view. It's a judgment only delivered in January 2020. And I'm sure this will be debated at some other forums as well. But I think one more important factor that Arbitration judgment highlighted was that the challenge to an arbitrator who is disqualified can be made to the court straight away. That could be done in, this was a petition under 14 and section 14 and section 15 of the Act. As we are all aware, it's a legislative policy and as well as the judicial outlook that the interference in arbitral process must be minimal. Section 5 of the Arbitration Act has a non-obstante clause. It starts with saying, notwithstanding anything said in any other law, except to the extent which is provided, no courts, no judicial authority will intervene. And if you look at the intervention, it's only in 4 or 5 places. The first, of course, is in aid of arbitration. You could summon witnesses. You could summon experts. You could then pass interim orders. These are all orders that are in favor of in aid of arbitration. And then, of course, you have, while the arbitration proceedings are pending, an exception where an arbitrator has limited his office, and that's under 14, section 14. And then, of course, there are appellate provisions where an interim order passed by an arbitral tribunal is appealed to the High Court. But otherwise, during the arbitral proceedings, there is no other scope for interference, at least in the first part of the Act. After, of course, the award is given, then there are separate provisions. But during the arbitral proceedings, that is commencement to its end, there is no interference. Of course, if the parties can't agree to an arbitration, the courts are under section 11 appointed. Now, this is how the Act currently is. Now, 2015 really brought about several changes in the Act. It sort of capped the fees for arbitrators. It fixed an upper limit of the time. It sort of limited the scope of examination at some stage. But I think the most important thing, which are the two most important features of the 2015 amendments, were the amendments brought to section 12 of the Arbitration Act. And of course, under 36, because now awards would be enforceable, notwithstanding that an appeal or an application is filed, which was not the case earlier. But 12 really was at sea changes. There was a substantial change in section 12. First change was in section 12.1, which required that before an arbitrator accepts his appointment, he has to make a disclosure whether he is otherwise there could be a challenge to his impartiality or independence in terms of any relationship that he has, which is specified in the 5th schedule. Well, if he had to make a disclosure, and depending on the disclosures, the parties would have their say. But if that challenge was thrown out, then an arbitrator decided otherwise in the end, because he was the authority who would ultimately decide whether he had whether he could be proceed further or not. Then the other party had no recourse. They had to run through the entire arbitration till an award was rendered and then raise the challenge again. But section 12.5, which was introduced, the subsection 5 of section 12 that was introduced, brought about a paradigm shift in this regime. And the paradigm shift was that notwithstanding, again a non-obstante clause, and notwithstanding any other provision, if a party was proposed to be appointed as an arbitrator, had a relationship that was specified in the 7th schedule, then he was disqualified. Unless the parties agreed in writing after the disputes had arisen, there was no question of him accepting and proceeding further with arbitration. Now, if a challenge was made before the arbitrator regarding his disqualification and he rejected it, now a party didn't have to wait till an arbitral award was rendered. It could have recourse to section 14. Now, this question first arose, this issue first arose in 2017 before the Delhi High Court. This was in a case of HRD versus Gale. This was a case of repeat arbitrations, but also whether a challenge to an arbitrator could be made under section 14. And I authored that judgment in the Delhi High Court. And this was a view that was taken, that you didn't have to wait and didn't have to go to the rigors of section 13, and you could straight away go to 14. This judgment was, of course, upheld by the Supreme Court, and Justice Nariman has laid down authoritative judgment as far as what could be the areas where a repeat appointment is permissible. But as far as this view is concerned, this was not disturbed, and in Pratidotor, it has been again reiterated that you could go under 14. Now, this is really, I think, one of the most important features as section 12 arises. Now, if you look at the legislative policy, the guiding factors have always been twofold. That if arbitration is to be effective, then it must be assured that it is unbiased. It is unbiased, and secondly, it is, and that's now gaining much ground, that it should not be whimsical. It should have some grounding in reality. You shouldn't have some outrageous awards that one has seen, and that's brought about some amount of disrepute to arbitration as a method for resolving disputes. Now, given these two pillars and these two objectives in mind, the government appointed a very high-powered committee under the chairmanship of Justice B.N. Sri Krishnan. And this committee was then, one of the terms of reference was to see how you can strengthen the arbitration in India, the object being to make it a hub. And that report was submitted, and it pointed out, and one of the important terms in that reference was, how do you strengthen institutional arbitrations? And a lot of stakeholders gave their view. I think Mr. Pacharanda also is mentioned in the report as one who gave his inputs. So they collected inputs from everybody, and they said institutional arbitrations in India have faltered for several reasons. One, there was some amount of misconception. Second, they said, was they didn't have institutional support, and therefore by government and by other institutions. And third is that it lacked the legislative backing. Now the question is, why did it lack institutional and government support? It begs the question by saying there was no investment. It's like a vicious circle. The persons who have the highest stake in arbitrations in the past, which would be PSUs and the government, didn't support institutional arbitrations. And why did they not support institutional arbitration? They did not do so because they thought it fit to control the constitution of the arbitral tribunal. Or if you want to have clauses where the determination of how the tribunal is to function remains with one party, then obviously it would not support an institutional arbitration. So you didn't have investments, you did not have into an institutional arbitrations. Because you did not have institutional investments in institutional arbitrations, they didn't develop, and because they didn't develop, you again didn't have any recourse to go to them. So it was like a vicious circle. Well, that I think has been the object of the next amendment that has been brought about in 2018. Now, somehow, somewhere, the pathways are being made to ensure that institutional arbitration is supported. We had in the beginning of this seminar a small clip of SFCA, and that's one institution. And now I think the time has come, at least the way forward is to strengthen these institutions. Now, world over, I think there was a report by Queen Mary College University of London and PricewaterhouseCoopers, which said about 86% of the awards rendered in the last year were from institutional arbitrations. We have estimated that approximately in India, 80% of them are ad hoc and 20% of them are by institution. Now, this must change. If the answer, if arbitration is to ultimately succeed and be accepted as one of the methods of dispute resolution, then it will be necessary to build institutions that can support under aegis of which arbitration can be conducted. And I think time has come to accept this wholeheartedly, the initiative that is now being taken both by the legislative as well as the executive. So you have two acts that have now come, 2018, which have brought about now a formation of a separate body that will rate arbitrators, it will rate the institutions, and then you can then elect PSUs, and other parties can then elect which institution would they want to go as far as the arbitration is concerned. And that, I think, will automatically take away this appointment of arbitrators by a unilateral clause. Arbitrators would then be appointed by the institution. And if we've seen world over, there are institutions where it's not only brick and mortar that is provided, there is also support that comes from manpower. I think ICC has a thorough examination of draft awards to ensure that no issue is left unanswered. There is a dialogue back and forth between the arbitral tribunal and the institution to ultimately ensure that the quality of awards remains something to look forward to. And I think this is another step that institutions must now espouse. And so therefore there is, and of course the second enactment that has happened recently is the New Delhi International Arbitration Center Act of 2019, where ICADR has been taken over by the government, and now you have the New Delhi International Arbitration Center. So I think really the way forward to cut through this Gordian knot of whether one party should appoint an arbitrator, or whether the other counterparty should challenge it on this ground. If we believe that the way forward is that there should be an unbiased arbitration and there should be no question raised on the arbitral tribunal, then I think the way forward is to accept the institutional arbitration and leave the appointment totally outside the scope of an arbitration clause and simply follow and adopt the rules which any institution would follow. And I think that should be the way forward, in my view. I think we've not far exceeded the time given.
No, not at all. Justice Bakru, that was excellent, and Gaurav. So that was the heavy part of the session where we talk about a lot of cases and change in legislation and approach, and now we come to the lighter section, but light, but not really, because it's actually quite a topical and sometimes problematic area, and this is an area of virtual hearing. And over the next 15-20 minutes, we'll talk a little bit about this, all three of us, and also take questions after the end of that on both topics. So in the 5 minutes that I have, let me run through what I see are the 5 challenges and their solutions to virtual hearings. What is a virtual hearing? Virtual hearing is not very different from.
Sir, Larry, sir, I'll just take a minute of your time. Sir, we are receiving a lot of questions from our YouTube viewers also. So, sir, I'm sharing the same with you on your WhatsApp. So please do check them side by side. Thank you. We have a lot of questions from YouTube.
Okay.
Sir. Yeah.
Okay.
Thank you. Sorry,
clearly,
sir.
YouTube is a more attractive form of communication. Maybe we should be on TikTok as well, if we are not. Yeah, what is a virtual hearing? For those of you are watching this with all speakers and organizers on the same screen, this is essentially what it is. It's no different from Gaurav acting from one side, I acting for the other, and Justice Bakru making a decision. That's essentially it, with Mr. Anuj and Mr. Sopti being witnesses who are being cross-examined. So in essence, it's not a very difficult concept to understand. But let's talk about 5 things. Firstly, this is, a lot of people think, oh my goodness, this is something very new, but actually it isn't. In international arbitration, almost everything apart from the final cross-examination of witnesses is done virtually, by telephone. Emergency arbitrator applications hardly ever done anything other than by telephone, because parties are in different jurisdictions and they have to deal with stuff urgently. A lot of applications don't even have hearings. They're done on paper. So the concept of virtual or remote or non-hearing hearings in international arbitration is not uncommon. So that's the first thing. Now, that is, of course, different from if you were in court. If you went to the Delhi High Court, on the whole, you would appear before a judge for most applications. But in international arbitration, that is not the case. So this is not something new. That's the first point. The second point, and this is what we are seeing, is that a respondent that does not wish to promote the conclusion of the hearing, and most respondents who do not have a counterclaim fall into that category, have now got this sort of bargaining chip in their hands that they don't agree to having the hearing in a virtual manner or remotely, and they will insist that the hearing can only take place when all parties are physically together. Now, given current conditions, we don't know when that might be. It could be months, could be years when that might happen. So the question arises, if the tribunal is minded, the arbitrators are minded, and one of the parties is minded, can the tribunal proceed? And one of the questions raised by one of the, in advance deals with that. Can the tribunal push ahead with a virtual hearing even if one party doesn't agree? And the answer to that lies in a 3-step analysis. The first is you look at the arbitration agreement between the parties and ask 2 questions. Does the agreement itself mandate an in-person or physical hearing? Because if it does, then, as we said earlier, the mandate of the arbitrator comes from the agreement of the parties, and unless parties agree otherwise, that has got to be the case. But in most cases, that is not stated in the arbitration agreement. Then you look at the second question. Is there anything in the arbitration agreement that restricts the ability of a tribunal to order that a virtual hearing be held? And again, most arbitration agreements do not, but it's worth checking. So if the answer to that is no, you go to the next stage. And the next stage is looking at the rules of arbitration that you have that the arbitration is being conducted in accordance with. I haven't seen any institutional rules that constrain the power of the tribunal to the manner in which the hearing is to be held. So most institutional rules won't have it. The ad hoc rules adopted by parties, there is a risk that parties may have agreed to an in-person physical hearing. And that again goes back to Justice Bakru's point and Mr. Sopti's point, is that try and adopt institutional rules which leave a lot of scope for the tribunal to make decisions in the interest of expeditious disposal of the dispute when stuff like this happens, when COVID happens or some other situation like this happens. So if the institutional rules don't prohibit it, the last port of call is the procedural law of the seat. Is there anything in the law of the seat that would constrain a tribunal's ability to conduct the proceedings and finalize the case and issue an award based on a virtual hearing? Again, most laws that are at least based on the UNCITRAL model law will not constrain the ability. And we already know, most of us arbitration practitioners, that the Evidence Act that applies to court proceedings does not apply to arbitration, and that is the case in most countries. So the tribunal has a very wide ambit, a very wide power to decide how evidence is to be brought forward. In fact, we are seeing some new laws that are being adopted, like in 2018, the UAE arbitration law, which has express mention of hearings by modern means of communication and taking of witness evidence without needing the witness to be physically present. So obviously in 2018, we can't say that they had enough foresight to foresee the current situation, but there are laws that are expressly allowing or empowering the tribunal to conduct a virtual hearing. Now, third, technology will play quite an important role in this virtual hearings, and this has to be tested. It has been tested. There are many providers like the one that we're using now, like Zoom, like other providers, where even people who don't have very sophisticated internet or applications, etc., just have a browser, can attend. Where there are patchy internet connections, this can be solved and are being solved by having hotspot, mobile phone hotspot. India has very good penetration on that, Wi-Fi dongles, etc. People who are concerned about confidentiality and encryption, there are measures adopted within the platforms that can allow what they call virtual waiting rooms, that you're not allowed into the main proceedings until somebody allows you in. So that is a control mechanism. And thirdly, documents. Your documents are not physically available to you, may not be. You may have them on the screen. So you will need some document management software or provider to help bring the documents up on the screen. Usually, we use 3 screens for any virtual hearing, any participant, one in which we are conducting the cross-examination with the witness, one on which the documents are, and the third, quite importantly, transcription. And this is where I go to the fourth point I'm making. Transcription, live transcription, is pretty much regularly used in international arbitration. And I know from my experience of cases and cases that I've worked with Gaurav, etc., that the take-up of transcription in India is somewhat slow, nascent. And maybe this virtual hearing is going to make that take-up even more prompt, because one of the most challenging things in a virtual hearing is for the witness. And a witness who is presenting his evidence, he's not sure whether he's heard the question properly or whether his answer has been communicated properly. And what better way than for the witness to have on one screen a live stream of what is being said by counsel, by the tribunal, by him coming up on screen, so that he can see live what is happening, and what can be misinterpreted, he can correct immediately. I believe the systems in some of the arbitrations I've seen in India has transcription, but it's more of a question put up on the screen, answer put up on the screen. So the process or the concept of a witness being comfortable with his evidence already exists, but I think virtual hearings will accelerate this, and particularly live transcription will help. And finally, the fifth point that I want to make is about cost. In international arbitration, a not insignificant amount of money is spent on tribunal members having to travel to and from their home to the seat of arbitration, lawyers, if they're not in the seat, traveling there, particularly for neutral seats. London, Singapore, Hong Kong are neutral seats. A lot of parties are not from there. A lot of law firms who are appearing are not from there. A lot of tribunal members are not from there. Most of these are actually business class airfares. It can amount to a lot. So you're doing away with all of that. You're doing away with, in cities which have a significant amount of traffic, you're doing away with delays to lawyers or tribunal members being able to turn up, or the hearing starting later to allow people to turn up outside of rush hours. The hearing can start at 9 o'clock sharp because everybody's at home. Everybody's attending without having to travel. So this has great potential for great efficiency. Now, there could be some concerns of additional cost of electronic documents and document handling and tech support. But on the whole, I think going forward, on balance, the efficiency that virtual hearings bring, outweighs the additional cost that might be involved. But that is, of course, from the perspective of a counsel who's presenting a case. Does this affect the quality of justice that is set down by a tribunal? We'll hear from Justice Bakru on that. And there are particular challenges, I believe, in India, or the practice in India, which I think, Gaurav, if I can hand it over to you now to talk about for virtual hearings. You've just finished one, and maybe you can talk a little bit about your experience on that.
So I thank you, Saurav. You make very valid points. From particularly the domestic arbitration perspective, there are, of course, all of us who appear in international arbitrations from time to time. We are quite comfortable with and are well aware of virtual hearings and all the facilities that are available there. But from a domestic arbitration perspective, I think there were issues that I noticed based on my own personal experience during the last 4 or 5 weeks in two very long virtual hearings, and particularly in final hearing matters. And I just thought that I will just make those points for you to think about. One of them, for example, is and which is more than obvious, is that there is a certain time lag between now and by the time the lawyers who use virtual hearings are up to speed with how virtual hearings work. So which a lot of our lawyers who have a substantial domestic arbitration practice will take at least 2 or 3 proper arbitrations before they're comfortable with virtual hearings generally. That's my point number 1. Training. Point number 2, I think in terms of infrastructure, because virtual hearings were not commonly resorted to in domestic arbitrations. So I think in terms of infrastructure, problems like how to prepare electronic bundles, how do we make sure that electronic bundles are viewed during a hearing by all the parties, while the counsel is referring to them. How best to make use of live transcription. So there are certain infrastructural issues. One thing which is very small, how does counsel take instructions during a virtual hearing? Does WhatsApp, would the tribunal allow you to take a few seconds off of you, maybe a minute or 2 off, to either talk to your instructing lawyer or client, or just get WhatsApp messages and take instructions? So I think in terms of infrastructure, again, there are small issues which will have to be addressed. Sometimes necessity is the mother of change, and I think it has alerted the legal community here as to what all is required to be done. So infrastructure is one of them. The third, I think, and which is an area of which is peculiar to India, is that while a lot of us, like Singapore, Indian courts have been at the forefront of use of technology in terms of conducting hearings. In many ways, I think we were always ahead of London, and we were nearly neck to neck with Singapore. The difficulty, however, is that all that works very well in appellate side matters, writ matters, and oral hearings. But how to use this technology or rely upon a virtual hearing, or use virtual hearing for a trial, for cross-examination of witnesses, examination of chief, then referring to sort of documents at an oral hearing, which can be seen all across by all the parties on the screen. Those are areas where a blend of training and technology will have to come in, because I think that is an area where all of us who have a large domestic arbitration component are slightly handicapped and not used to. But again, as I said, it's a matter of time. I hope that the lockdown sort of gets lifted gradually, but if it was to continue for another 4 or 6 weeks, I'm telling you, by the end of this year, you'll find the most competent virtual hearing experts amongst Indian lawyers here. Those are the points that I would like to make sure of. But I look forward to hearing to Justice Bakru's views as to what is his perspective, how efficient he finds the use of virtual hearings in terms of dispensation of justice.
Thank you, Gaurav. I think I have little to add after all of the points that you highlighted. So let me tell you our experience as far as courts are concerned. Well, one thing is clear: the problems that you face in a court hearing are manifold more than what you would face as an arbitration is concerned, because there is just there's just 2 sides, and then and only one single matter that will be looked into. In court hearings, you have to do multiple number of matters, and therefore there is a challenge as to how many matters can you get over, how many cases can you finish in a given point of time, because you have to log out of meetings and log in to separate meetings. Sometimes there are connectivity issues where lawyers are not able to join in. But I think you can look at Supreme Court as how it's conducting its hearings, and I think it's really going without a glitch. For one, everybody joins in. They just give their item numbers and they join in. And the central control room then unmutes only those participants whose case is called out. And therefore, they're able to dispose of far more, a larger number of cases than I think in other courts. Well, that's, like you said, now almost virtual hearings are a reality. One wishes that it didn't come for the reason that it did, but now I think everybody is used to it. Now, going forward in arbitration, I think even after this emergent situation that we are now in dies down, virtual hearings and arbitrations would continue because a lot of persons have found ease of it. The ease of having a virtual hearing is far too great to simply give it up. But so the councils are appearing in different countries or different states. Arbitrators are from different states and different parts, and all of them can come together. Now, coming to the second point, so there's no really problem in having a virtual hearing as far as arbitration is concerned. It will follow the same pattern as a normal hearing does. There are some issues that arise out of witness action, and I think Mr. Larry pointed it out, and one must underscore it, that one doesn't look for where you have the permission to hold a virtual hearing. You have to look where the restriction is to do so. What is it that prevents you from doing so? And this is it reminds me of one of the earlier cases that came to Supreme Court in 2003. This was a bench of Justice Varyava who was presiding the bench, and it was a very interesting question that came. It came from Bombay High Court in a criminal matter. It was, I think, State of Bombay versus Dr. Praful Desai. It was a doctor's matter. There was a criminal case brought against a doctor by a particular patient who had died because he had conducted an operation which he shouldn't have. And one doctor in the United States of America had advised that don't do that operation. And he was to give his testimony, and this was a testimony in the CRPC, not under the civil code or not where you have no procedure. It was in criminal procedure court. And the arguments that were, the Bombay High Court said, no, you can't do it because under 273 CRPC, it must be in presence of the accused. That's how criminal law proceeds. The matter came to the Supreme Court, and the arguments raised were very interesting. Number one was, what happens if the witness commits perjury? Then he's not within your jurisdiction because he's sitting in some other country and then you can't control him. Then, of course, what happens if he's prompted? And because there may be somebody else in the room, and so on and so forth. So it's worth reading that judgment because Justice Varyava dealt with each of these points. He said, what about perjury? He said, doesn't matter. Many times witnesses come, depose, and then go out of the country. So how would that be any different from a person who is anyway outside? And he allowed that virtual hearing, and the doctor did give his testimony from the United States by virtual hearing. And all of these issues that were brought up, that could be challenges that a person is not present, he would not have heard this question, he would not have answered, his answer may not have been captured correctly, he may be under some other pressure, he would be outside the control of the court. All of these were answered and repelled. Delhi High Court took this up forward. If you look at it, we have guidelines issued of how witness action is to be done by virtual hearing, and these are old guidelines that tell you that there has to be a coordinator on the other side who would be present with the witness, and he would then certify that none of this, he wasn't prompted or he understood, and so on and so forth. There was a right down to the cost. So if you just look at those guidelines, I think they run into 9 pages, but there are extensive guidelines on how do you record testimonies of witnesses by virtual hearing. And this was way back, I think, in over a decade ago, or probably several years ago at least. But this judgment in 2003 actually paved the way of holding witness action by virtual hearing. And what Mr. Larry said was, where was the restriction? That's exactly the thought of Justice Vareva, that although CRPC says it must be held in presence of the accused, where is the restriction not to do so? So he expanded the law there and still holds the field. So when it comes to arbitration, I think the issues are far less complicated, and the ease of having a virtual hearing is far greater to give up, as pointed out. But yes, we would require training, and as time goes by, more and more persons will become more proficient in sharing documents online or filing your documents online. And I think most of the topic here is covered. Proceed with some questions and answers and see if there are some issues.
Thank you, Gaurav. Thank you, Justice Bakru. It has fallen to my part to try and collate questions that have arrived from 3 separate channels, and I will try and do the best I can. If I can't cover all of them, please forgive me. We have about 15 minutes left for this session. We'll take questions about unilateral appointments first, and then do a little bit on virtual hearings. There are questions that go beyond the scope of today's topic, for instance, arbitrator timelines and fees. So forgive us, we will not be covering them in this session. We can do that in another session, so I'll keep it topical. And Gaurav, perhaps I can start with you. There is a question which is quite interesting, which one of the participants has raised, and I believe this is a gentleman from Garden Reach Shipbuilders and Engineers. In an ongoing arbitration initiated prior to 2015, if the arbitrator resigns now and a substitute arbitrator is required to be appointed, will the appointment of the substitute arbitrator be governed by the amendments made to the 2015 Act? And then who should be the appointing authority? In view of the judgments that Justice Bakru and you talked about, TRF and Perkins, because the CPSU had incorporated the standard arbitration clause, which would, its CMD could act or appoint an arbitrator. What do you believe would be the situation today, Gaurav?
Saurav, in my assessment, I think there is no difficulty at all if the original appointment was made in accordance with the old regime, where there was no prohibition on a unilateral appointment. Then under Section 15, the same rule has to be followed, even in the case of a replacement of the arbitrator. So I don't think there will be any problem in following the same process by which the original appointment took place.
Okay, and Justice Bakru, something that has come for you in particular, and I think it links back into one of the points you made about your HRD and Gale case. And the question really is this, that following the judgments of TRF and Eastman Perkins, and with the recent Predator judgment, if an appointment is challenged of a sole arbitrator in certain situations, for instance, where the arguments have been completed by parties and award is yet to be announced, or cross-examination of the witness has been completed, arguments partly completed, or earlier pleadings have been completed, issues framed, an affidavit of witness filed, and all of these, the arbitrator was under the old regime, let's say, done by the CMD of the PSU. How would you view a party's approach to these sort of situations and the timing that you were talking about as to when a concern or a challenge could be brought? Actually,
Mr. Larry, the question that you asked is a really vexed one. That was what happens when an arbitrator is appointed in the pre-2015 regime and an event happens post the enactment. Now, there are two views to this, and I'm telling you and hedging my bets here because both of the views are very, very powerful views. One of the views was that since the Act would apply only for arbitration proceedings, that Amendment Act would apply only for arbitration proceedings that had commenced after 26th October, which was the day when the ordinance had come forth. Then all arbitration proceedings that had commenced prior to that would not be affected. Now, this is a straight answer because arbitration proceedings under Section 21 commence when a request for arbitration is made. Now, this is one view. Now, there is another view that has been gaining some ground, and that comes in the view by saying that if the legislature had addressed an anomaly, then why must you reduce the bite of that legislature to only the provisions which were there prospectively? So why should you not grant this benefit to arbitrations that had commenced thereafter? This was also a subject matter of one of the judgments of the Supreme Court, which talked about whether the 2015 amendment is prospective or not. And this judgment was then sought to be over BCCI, I think. And this was sought to be overcome by the 2018 Act by saying, no, as what Mr. Pacharanda said is correct, this is what you have to follow. There's a cutoff point, and what has happened, what is in the past should remain. Now, that has been struck down by the Supreme Court. Constitutional validity of that has been struck down by the Supreme Court. So this is not an answer which one can say in affirmative or in negative. With this, if you look at the rival contentions, I think there is much to be argued on both sides, and this question would, I think, would be a live question to be answered at some stage. Therefore, for me to express an opinion offhand would neither be fair to the persons who are hearing it nor to the court. But I've pointed out how the two arguments are functioning, are proceeding in this case. I had occasion to author a view, and I must state that it was a judgment called Raffles, and I expressed the view that even though the 2015 amendment came from 26 October, certain events that were happening thereafter would follow that. That was in the context of Section 9, whether a Section 9 order could be given for a foreign arbitrator, for foreign arbitration. But the essential issue was the same, whether typically what happens when an arbitrator demits office. Should you discard the post amendment? But technically, I would think Mr. Pacharanda is right. As the letter of the law stands, those arbitrations that have commenced prior to 26 October 2015 would then follow the regime which was pre-amended. And then there is no restriction in those.
Thank you, Justice Bakru. I can say that your decision in Raffles Design and EduComp created a lot of waves where I come from here. Because it dealt with the Singapore Award. So we have not forgotten that. And thank you also for setting out the two perspectives. Of course, this is a live issue, and I think probably quite topical because there are a number of questions along these lines. I've taken the one that was most specific. And another one, again, linked to this, and maybe again for both, maybe I start with Gaurav and Justice Bakru can add if you'd like. The question comes from Railtel. In view of the Perkins judgment of the Supreme Court, what would be the best standard arbitration clause for appointment of a sole arbitrator? One way is to keep the appointment as mutual, but would it be legally valid if we say that the sole arbitrator will be appointed by Party A rather than CMD of Party A? Can we avoid the rigor of the Perkins judgment by drafting the clause in that way? And I think, again, you may have touched on this, Gaurav, but perhaps you could take this up if you could.
So my view on that is that based on the Delhi High Court judgment that I just mentioned, product of cable TV, I think it may not be safe any longer for a party to say that instead of the managing director, it is for a party to appoint it, make a unilateral appointment. That will run into trouble. The safest arbitration clause would be where the appointment of an arbitrator is deferred to or relegated to a third party, an institution, or if it's not by consent, then it default by an institution. There is an alternative view. If you look at the Supreme Court judgment in Voista Alpine, I think, and particularly even in the case of the latest judgment, I'm forgetting the name, Central Railway. I think it might be possible. I think Vista Pipeline particularly refers to this and says that at least for the purpose of disqualification, the disqualification would apply either to the Vista Pipeline says that the disqualification will apply to the appointing authority if it falls within the meaning of 7th schedule. The Delhi High Court says that it might even extend to the party involved in the contract. But I think in the context of PSUs, and this is a halfway suggestion, I think I'm not too sure whether this would work, but I think it is possible to say that a PSU may not make a unilateral appointment itself, nor its board, nor the managing director, but it is possible for the ministry to make that appointment. This is, as I said, a halfway suggestion. One does not know how it would be perceived. In Vista Pipeline, I think they said, Vista Alpine, they said specifically that this does not apply so much to, in the context of government, if this applies to employees of the Delhi Metro Corporation, but does not apply to employees of the government. But I think the safest answer would be to defer to a third party rather than any party that you're connected with. I wonder what Justice Bakru's views on this.
Justice Bakru, would you like to say a few words on that?
Yeah, I quite concur with what Mr. Pachanda said, but I want to just put the question here in return. Why should there be so much of a desire for one party to say that we must appoint the arbitrator? I think the whole fallacy lies from this thought that has plagued arbitration for a very long time. And like I said earlier, if you really want arbitrations to be accepted, it should not only be accepted by the party appointing the arbitrator. In the minds of the other contracting party, he should go back after having a award by being assured that it was a fair award. And that won't come if you have a single party appointing it. So I think the time has come now to sort of stop thinking on these lines and start thinking on the lines of looking for a fair award and ensuring that it's an administered, fairly appointed arbitrator, rather than scrambling for control of the constituting the arbitral tribunal.
Thank you, Justice Bakru. I know there are a lot of questions, but we have very little time left, so I'll take one up on virtual hearings, which I think cuts across.
Just one minute to Mr. Larry. If the eminent panelists they agree, we can extend it by 15 minutes if they have got time, because so many questions are coming. Justice Bakru, will it be possible?
No, it's all right. It's all right by me. If you can extend it, I'm not difficult.
Okay.
Okay.
Thank you, sir.
Okay. Let me ask this one on virtual hearings, and then let me consult my notes on what else to ask, because I was trying to keep it limited to this. But this is an interesting question which has come up. I'm combining three questions, and this is in relation to the legality or the acceptability of an award that is the result of a virtual hearing where one party did not agree. And could the award issued, for instance, there is a question, would the award issued be subject to offending Section 18 of the Arbitration Act, which I believe deals with the principle of equality between the parties, and I address that. But in a broader sense, of course, your views, Gaurav and Justice Bakru, on where we are talking about a situation where parties are not in agreement, but the tribunal is not constrained, has directed that the hearing be proceed. What would happen to an award issued? Can the party not agreeing challenge it on purely the basis that he wasn't in agreement? Now, I'll deal with the question of equality first, and then hand it over to Gaurav and Justice Bakru. I don't believe the principle of equal treatment of parties is affected, provided both parties are coming up or presenting themselves under the same conditions. For instance, just because the tribunal and one of the parties is in the same location, it should not mean that they should be in a room together, whereas the other party is dialing in remotely. So in a matter that recently I've been dealing with, we have undertaken that even though we will comply with the same restrictions that the other party is under, so that there is equality of arms, equality of presentation. and there can be no question about any party being treated unfairly or unequally. So that's on the equality point. I don't think that's affected. In terms of both council approach in India and the judiciary, Gaurav, would you want to share some thoughts on what you think? Of course, we don't know because it hasn't come up yet, but do you think this might offend certain closely held principles in arbitration in India or practice in India? You could not?
I don't think, Saurabh, there can be a broad and generic answer to this question. There might be a situation where a party has objected to participation by video conference, yet the tribunal has required that the hearing will go ahead with video conference, and the party did participate. So really, that would be one extreme of the situation. There would be another extreme of the situation where the tribunal directed both parties to participate by video conference, but the party did not participate only because it wanted to delay, and it's sometimes very obvious as to the nature of objections raised by it. And then there might be a third situation where the party was not able to participate in the arbitration because of reasons that are beyond its control. For example, if one of the parties is based in a very far-flung small town where it does not have the facility to participate fully and properly, what would be the result of that? So I think in those cases, perhaps Section 18 might get triggered. It's very difficult to, I mean, without going into specifics and facts, it's very difficult to give a general answer. But I think as a general rule, I mean, one cannot say that simply because a tribunal required a virtual hearing, that itself can be used as a ground, because that's really, in the absence of a contract to the contrary, that is really within the domain of the tribunal. Nothing prevents it from asking for a virtual hearing.
Justice Bakru, to you.
Yeah, I think the answer to your question would lie in looking at Section 34 itself. Section 34 sets down the grounds on which you can challenge an award, and which, if there is a real prejudice, as Mr. Pacharanda pointed out, that there was a disability for the party to participate, and he can show it, then that it goes into a separate clause, that he didn't have the opportunity to participate in the hearing. I don't think it's a question of 18. So much as it is a question of 34, because now you say the award is already being rendered. At that stage, the only thing that matters is under which clause does it fall under 34. And if it was not that the part, if it can't be established that the party was under some handicap and couldn't participate, then that clause goes, and then you're left with public policy. And I don't think anything in public policy clause gets offended if the hearing is held by virtual video conferencing, provided that both the parties had a full opportunity to participate in it. So I think the shift would be seeing in which particular clause does it fall under 34. Otherwise, if it doesn't fall, it doesn't fall. As you know, if it doesn't fall under 34, then you may have issues with the award, but it doesn't get set aside.
Yeah, thank you, Gaurav and Mr. Bakru. On virtual hearings, before we move back to the issue of unilateral appointments, on which there are a lot of questions, there is one question which I think is quite important, and the question comes from Mr. Chandra, who is at NHPC. The question is, what will be the seat of arbitration in the case of a virtual hearing? And I think this sort of betrays this constant toing and froing that's going on, I think particularly in India more than other places in the world, about the seat and place and venue. And the short answer, and invite Gaurav and Justice Bakru to comment, short answer is there will be no change to the seat at all, because the seat is just a juridical place of the arbitration. There might be a change to the venue of the arbitration, but the venue is legally irrelevant. And then the question is, what happens to the place of the arbitration? And then we have all these cases as to what place means. Does place mean venue? Does place mean seat? To the extent place means seat, there will be no difference, no change. To the place means venue, there may be a change, but again, a venue is not something, unless the arbitration agreement or the rules constrain it, a venue is something that is open to the tribunal to determine. I hand it over to Gaurav and Justice Bakru in the thick of all these discussions that are going on in India.
I have a shorter comment on this. I agree with you entirely, and I don't think there's anything more to add. It's really it's really in terms of seat of arbitration, it really would have no impact, and it's really an issue of venue, and that might get impacted in certain situations. But really, as far as seat is concerned, I think there is no impact.
Yeah, I think this is not an issue in the sense whether it was virtual or whether it was not makes no difference. The seat remains the same. It's as far as place is concerned, that at the beginning of the arbitral proceedings, the arbitrator fixes the place, so that determination would have already taken place. Holding a virtual hearing doesn't alter it one way or the other.
Okay, thank you, and I hope that helps those who you have asked that question. There are several of you asked questions around that theme. Coming back to unilateral appointment and this vexing question, particularly for PSUs, there is a question from Mr. Singh, Mr. Paramjit Singh. In many CPSEs, CMD is specified as the appointing authority, especially for sole arbitrator cases. Now, subsequent to the Perkins judgment, what would be the advice for contracts under execution? I think under execution meant by in process already, rather than waiting to be executed and signed, but contracts that are already in place but the arbitration has not started. How would Gaurav, perhaps one for you, much more so than Justice Bakru, what would be the principles that parties should consider in such contracts, given the latest state of the law?
So I think it's very clear that in terms of any arbitration that is commenced post 2015 amendment, that unilateral arbitration clause has become unworkable, and an arbitrator appointed pursuant to that clause would be removed under Section 14. He would de jure become incapable of acting as an arbitrator. What is the way forward? They should immediately, the way forward is that if there is a sole arbitration clause and the unilateral appointment procedure is unworkable by declaration of law anymore, then the best way forward is to appoint a sole arbitrator by consent. And if that doesn't work out, there will be a default appointment under Section 11 of the Arbitration Act. Of course, going forward, if they're still rewriting the clauses, then the clauses should create a mechanism for a third party, independent party, to appoint an arbitrator.
Thank you. I'm now looking at some of the other questions. There is a very specific question in relation to evidence adduced during virtual hearings, and this is whether evidence by video conference would be in the nature of electronic evidence, even for the purposes of oral testimony within the meaning of Section 65B of, I believe, the Indian Evidence Act. Of course, the Evidence Act, the writer notes, is not agreed to be applicable to the arbitration, but perhaps this is a wider question in case the Evidence Act was made applicable or in court proceedings. Perhaps Gaurav, would you like to comment on that? If this is something that you...
As far as arbitrations are concerned, there would be no application of the Evidence Act. So really, that is a question that doesn't arise for arbitrations. In terms of if we are referring only to cross-examination of witnesses by virtual hearings, then I think it would be akin to oral examination. And I think if you're just referring to the examination in chief and then cross-examination questions, those wouldn't necessarily be electronic records.
Okay, thank you. I'm just give me one moment. I'm trying to do this on the fly. I believe there is a question about the applicability or the constraints under the Indian Arbitration Act in relation to arbitrators and for international contracts, and whether this would cover PSC's international business as well. I'll take a shot at that. If it really depends on what the applicable law is of the procedure of the arbitration, because arbitrator appointments are considered a matter of procedure, I believe. So if the procedure is governed by the Indian Arbitration Act, regardless of whether the other party is international or domestic, I think the same principles would apply. If the seat of the arbitration is outside of the country, you would need to look at the position under those rules, whether there are any constraints. But the kind of constraints that Gaurav and Justice Bakru have been talking about and looking forward, and even the guidance Justice Bakru gave, are general basic principles of arbitration adopted throughout the world. While parties are given some sort of latitude to fashion bespoke arbitration agreements, it must not move so far as to limit a party's choice as to who can be his arbitrator in a three-party arbitration tribunal, whereas giving the other party completely unfettered choice. I think you may have some difficulties in those sort of clauses wherever you are. I think, just one moment.
Sir, maybe last two questions.
Yeah, so I've got one last question which I have reserved for Justice Bakru. So I'm going to try and find one for before that. Yeah, which I think many of these have been, they're just some, people keep sending it in, the list keeps growing. Yeah, so, okay, one virtual hearings point, and this is perhaps both Gaurav and you can comment on the award. In virtual hearings, this is Mr. Rajendra Agarwal. In virtual hearings, the award is to be signed in person or can be signed on PDF files remotely. I've just been looking at this question under UAE law, and the UAE law in the past meant that arbitration awards needed to be signed actually in the seat in Dubai or Abu Dhabi, but that has been changed by the new arbitration law, so it's deemed issued at the seat of arbitration regardless of where it's signed. The position in India, Gaurav?
So in my experience, we really haven't had any difficulty because the awards are signed physically by the arbitrators and scanned and sent to us. It's only us not receiving a signed copy of the award in due course. So I haven't really come across a case where it's electronically signed, but if there was an electronic signature, I can't think of a reason why the award would not be valid for that reason. But in reality, what would happen, even in the international arbitration that I've seen, is really they sign a physical copy of the award, and that's scanned and sent to the parties, and eventually you do get a signed hard copy as well.
So as far as signatures are concerned, it has got two significance. One is making of the award, it requires to be signed, and second is for the period of limitation. A signed copy has to be provided to the parties. So now there is, of course, Gaurav can correct me if my memory fails me here, but I think there is a judgment which is proceeded on the basis of expanding on what is meant by a signature. And if you look at the definition of signature in historically, it would be meant a mark, so a person could put a cross. So in many cases, a photocopy which has a mark, not necessarily a full signature, the mark of a arbitrator may be construed as a signed award. So if that is a thought, then I don't see why electronically signed electronic signatures on a document would not be considered as signatures. So if you expand the definition of signatures to consider electronic signatures as signatures, then I think it should be good. But I do not offhand recollect, apart from that one judgment on which proceeds, that was on the question of limitation under 34, because the arbitrator had sent a photocopy with a small mark on it, and it had a full signature of it, but he put his stamp in the original, rubber stamp original on the photocopy of the signature. And the question arose whether that was an original for the purpose of limitation or not. Subject to correction, I think the decision was that stamp along with it was his mark. And since mark is supposed to be, signature is defined as a mark, then you could have held that. So I think there may be, in this context, it may be worthwhile looking at some of those precedents. But
this is the benefit of having a judge on the panel. Who knows more cases than all of us combined would do. As instructed by Samriddhi, I will ask the last question. And Justice Bakru, this is really for you, and because it relates to practice and guidance for all PSUs. And the question is quite potent and says, sir, in PSUs, one is supposed to challenge the award until the last avenue available. Given the unwritten rule and the default mindset, how can we improve the enforceability of arbitration? And leave that question and answer with you, Justice Bakru.
I think that's where we're coming. We must have a somewhat change in the mindset, because you may challenge an award because just for the reason of challenging it, but it just defers everything for about 2 years or 1.5 years, because that's the minimum time it takes in courts. But I think there is time to take a little more introspection and look at the awards that have come. Look at some of the international awards that have come against PSUs, and I've had the occasion to examine some of them. One finds that a significant amount is actually been attributed to some level of indecision. The persons who didn't take a call at that particular point of time has resulted in, didn't send out the correct communication by saying we're accepting this, has led to a humongous awards. So I think the real answer is not really to look and accept it as a given situation that come what way we must challenge the award and we must exhaust the procedure. I think the question is to raise it there at the level of starting. It's not really a question of the courts dealing it. It's a question of how the parties deal with it. At some point of time, everybody knows the law. If there is some problem with it, by all means challenge it. But otherwise, that mindset I think must have to change. Otherwise, we would be inundated with courts. It would actually take away from the time that you would actually devote to cases which really require looking into. So I think this thought that we must keep challenging it. But I guess if you must challenge it, then at least make a summary of what your challenge is, because you are normally thumped with some 3,000 pages on that desk, and then you have to go through them to find out what really is the challenge. And even that challenge is in more cases than just a repeat of the entire arguments that were placed before the arbitral tribunal. I think that's something that we must address ourselves. And I would sincerely hope that every time an award comes, there is some level of introspection on why the award has come, rather than simply say, "Oh, the arbitrator decided against us." Now, somewhere down the line, there are some merits of that case, why it went the way it did. And I think if parties, like it happens in other private organizations, people review on why the cases went the way they did. I think that review must happen even at PSU, even with PSUs.
Thank you. I hand it back over to Samriddhi and the scope team and Mr. Sokti, Mr. Agarwal.
Thank you, sir. Thanks a lot for taking up the Q&A so patiently, and special thanks to Justice Bakru. Sir, thanks a lot for your time, Justice Bakru and Gaurav sir. And Shaurav sir, of course. As the DG sir said, we consider you a part of scope now, sir. So pardon me if I forget to mention you. So thank you, esteemed panelists, very informative and enlightening. Now, before we move ahead with the closing remarks and closing the session officially, I would request all the participants, all the attendees, to please spare a minute from your webinar and give us a feedback. The poll is going live now, so please give us a feedback so that we can improve. The poll is going live on your screen. Scope technical team, please put the poll live. Attendees, please give your feedback so that we can improve. Thank you all. Scope technical team, we can close the poll now and get the panelists back on the screen. Thank you. So thank you attendees for your response. Now, before we officially close, I would request Shri Anuj Agarwalji, Member HR, Airports Authority of India Limited, and Executive Board Member Scope, to kindly give his closing remarks. Over to you, sir.
Thank you, Samini. Yes, this has been an very enlightening and very engaging webinar, and I'm sure all the participants they have enjoyed it. In fact, the topic which was there today, which is so relevant, uh, and I think during in the next few months, the issues of arbitration would assume much more increase. There are likely increase because when there has been a lockdown, there has been a closure of the activities. There would always be some kind of disputes between the parties who are managing, or the space which has been rented out, the economic activities, the contract which are there. So all those things, I'm sure that there could be a spurt in the activities of the legal disputes, and of course that makes the arbitration would the cases of arbitration would go. Now, I think it's been well covered by the panels, the senior panels, of course, Justice Bakru, uh, Shri Gaurav Pachnanda, the senior advocate, and of course, supported by Saurav. So, the topics which has been covered here, I'm sure that this would be a very useful discussions here. And the virtual hearing, which I'm sure that now would be new normal, one can say, and now we'll have to start evolving. We'll have to start make ourselves more acceptable to this. The infrastructure which will be required, which has been now mentioned by Mr. Pachananda also, that over a period of time we'll be start evolving. Now we maybe in few months time our system would be in place for taking care of all these, the infrastructure part, and of course the virtual hearing, when while there could be while we all understand that there's a lockdown presently, there will be restrictions in the movement. Even if these restrictions in the movement do released, but then there'll be people would not be prepared, at least for next few months, or maybe for a couple of years, to move. So that's a new reality, and once we are get used to of this virtual hearing, I'm sure that even if things gets normal, the virtual hearing would have to stay. And since this, when the people get used to it, when the people get they see the advantage of it, the timeline, the flexibility in the timeline, the cost effectiveness, because of all these things, the virtual hearing would definitely going to stay. And I think lot many things have been cleared here, but of course there have been large number of questions, and I'm sure that with such topic, when you have so many of participants, so many of the questions, I'm sure that all of them could not be answered in this limited time, but this has been a good opportunity for all of us to understand. And of course, the DG Scope and his team who have organized this program today, this has been, I feel that very, very effective and very useful. And the feedback also, I'm sure that you'll be getting the feedback on these lines. And we should continue to organize such more programs. I once again would like to thanks the panel, Justice Bakru, Mr. Gaurav Pachnanda, and Mr. Saurabh, and of course the complete team of the Scope who has organized this. Some of them are not visible here, some of them from behind the scenes. So all of them, I would like to convey my thanks. Thank you so much.
Thank you, sir. Indeed, sir, the new normals have been discussed today. So we assure you that Scope would continue to do the best in the field. And Before we officially close the webinar, I would like to express my thanks. Scope would like to express its thanks to the esteemed panelists for their time and guidance. Indeed, it was an honor to listen to Justice Bakru and a privilege to receive guidance from Gaurav sir and Shaurav sir. Thank you, DG sir, for motivating us. Thank you, Anuj sir, for being with us. And gratitude to all the participants for their enthusiastic participation. And we wish to meet you again on Monday, 25th May 2020, with a webinar on leading through uncharted waters, which is a conversation of the chief executives of leading PSCs in conversation with Gurudev Sri Shankarji, Ravi Shankarji at 6:35 p.m. The same is being shared on your screens as well. So please make yourself available so that you can avail the best of Guruji's guidance. Now with this, we officially come to the end of the webinar. And before, I would like to express my thanks to the entire SCOPE team, especially to our heads, Mr. S.A. Khan and Mr. Shubratna, for being always with us. And thank you, SCOPE team, for putting the teamwork and doing such a wonderful job. So thanks a lot. Thanks once again to the esteemed panelists. Thank you all. Until we meet again, we officially end the webinar. Thank you very much.
Thank you. Thank you very much. Thank you.
Thank you.
Thank you.